Supreme Court, in the case of GYANENDRA Singh versus the state of Uttar Pradesh, directed that the ends of justice would be served by restoring the judgment of the trial court and directing sentence of life imprisonment awarded to accused by trial court for the offence under Section 3(4) of POCSO Act shall stand revived. For the offences punishable under Section 376(2)(f) and 376(2)(i) of IPC, accused is sentenced to undergo imprisonment for life as awarded by trial court without stipulation that the life term will inure till the natural life of the appellant and fine of rupees 5 lakh, and in default to further undergo imprisonment of 2 years. Both the sentences shall run concurrently. The appellant GYANENDRA Singh was father of the victim, who was about 9 years at time of incident. On 28 October 2015, an FIR came to be lodged by wife of appellant Srimati Rajni at police station Chandpur district Fatehpur, alleging that she had gone to her parental house about 2 months ago with youngest son Krishna, aged 2 years, leaving her minor daughter victim, aged about 9 years, and son named Vishnu, aged 4 years, at matrimonial house in custody of her husband, that is appellant. On 22nd October 2015 at 8 p.m, appellant enticed the minor victim and took her to rooftop and committed sexual assault upon child. She was detained on the roof by threatening her. Minor victim came down from roof in morning and narrated whole incident to grandfather Ramnaresh Singh, who telephonically informed the informant about occurrence. Appellant went absconding after the incident. Informant got frightened because of incident, did not go to her matrimonial home. She somehow mustered courage and approached police station along with Ranjit Singh, her father, and father-in-law Ramnaresh Singh, as well as victim, and filed the FIR against appellant. It was urged in FIR that child victim should be medically examined. It was also stated in FIR that a day prior to lodging of report, informant had approached district headquarters Fatehpur, from where she was directed to approach police station Chandpur for lodging FIR. A bare perusal of Section 42 of POCSO Act would make it clear that when alleged acts or omissions constitute offence both under IPC and POCSO, then the law which prescribes punishment of greater degree would have to be applied. Courts have been given discretion to award punishment for terms sentence of minimum 10 years and for imprisonment for life. Where sentence awarded in discretion of court is for life, same shall mean imprisonment for remainder of that person's natural life. Hence, there is no mandate of law that under these provisions, convict must be awarded life imprisonment. The trial court, however, had awarded imprisonment for life to appellant while convicting him for offences punishable under Section 376(2)(f) and 376(2)(i) of IPC. Since said sections of IPC provide for higher sentence as compared to Section 3(4) of POCSO Act, trial court was justified in choosing the former to award punishment in terms of Section 42 of POCSO Act. However, court said we have to consider whether the award of imprisonment for life, which means imprisonment for remainder of person's natural life, was warranted in facts and circumstances of the case. The High Court, while deciding the appeal against conviction preferred by the appellant, observed that sentence of life imprisonment awarded by trial court for offences punishable under Section 376(2)(f) and 376(2)(i) of IPC would extend to remainder of natural life of appellant. This direction was merely clarification to keep the sentence in tune with language of sentencing provision. Nevertheless, fact remains that because of this clarification, rigor of sentence awarded has been increased to the effect that appellant would have to spend remainder of his natural life in prison without any possibility of early release. In the case of Virendra versus State of Madhya Pradesh, this court, while considering the case involving offences under POCSO Act as well as under 376(2)(i) of IPC, confined the life imprisonment to mean actual imprisonment for a period of 30 years. While doing so, bench relied upon celebrated judgment of court in the case of Swami Shraddhananda versus State of Karnataka.